Okay. President Bush's pardon of Caspar Weinberger and other Iran-Contra defendants undermines the principle that no man is above the law. It demonstrates that powerful people with powerful allies can commit serious crimes in high office, deliberately abusing the public trust without consequences. Weinberger faced 4 felony charges. He deserved to be tried by a jury of citizens. Although it is the president's prerogative to grant pardons, it is every American's right that the criminal justice system be administered fairly, regardless of a person's rank and connections. The Iran-Contra cover-up has continued for more than 6 years. It has now been completed with the pardon of Caspar Weinberger. We will make a full report on our findings to Congress and the public, describing the details and extent of this cover-up. Weinberger's early and deliberate decision to conceal and withhold extensive contemporaneous notes of the Iran-Contra matter radically altered the official investigations and possibly forestalled timely impeachment proceedings against President Reagan and other officials. Weinberger's notes contain evidence of a conspiracy among the highest-ranking Reagan administration officials to lie to Congress and the American public. Because these notes were withheld from investigators for years, many of the leads were impossible to follow. Key witnesses had purportedly forgotten what was said and done, and statutes of limitations had expired. Weinberger's concealment of notes is a part of a disturbing pattern of deception and obstruction that permeated the highest levels of the Reagan and Bush administrations. The office was informed, my office was informed, only within the past 2 weeks, on December 11th, 1992, that President Bush had failed to produce to investigators his own highly relevant contemporaneous notes, despite repeated requests for such documents. The production of these notes is still ongoing and will lead to appropriate action. Some would have to be furnished to Weinberger. They could have led to President Bush being called as a witness in that case. In light of President Bush's own misconduct, we are gravely concerned by his decision to pardon others who lied to Congress and obstructed official investigations. Thank you.
Mr. Walsh, do you figure that Mr. Bush was trying to insulate himself from this investigation with his pardon?
I'm not going to get into a further discussion of those facts now. Although the investigation has been seriously damaged by President Bush's action today, it is not over, and so therefore I will not comment on it.
What about the office of independent counsel? Does this seriously damage any hope of prosecuting someone? Is there another way that can be found to do an investigation like this?
For all practical purposes, I think it does seriously damage it. There are theoretical ways in which we could proceed by further interrogation, grants of immunity and things like that. But for all practical purposes, I think this is a very, very damaging blow.
Mr. Walsh, what direction remains open for the investigation now?
Well, we have still to complete the work on President Bush's own records that we're just receiving. We will have to make a final reevaluation of our position as to persons who have been pardoned. And then, of course, our biggest job from now on will be the completion of the final report. The timing of that report had been planned for mid-spring because of the schedule of our cases. The Weinberger case was scheduled to begin on January 5th, and the Claridge case was scheduled to begin on March 15th. And so the report could not have been filed if those cases were tried before probably the end of April or early May. We will now have to see whether we can change that schedule and realign our resources appropriately.
Does this bring to an end any possibility of any prosecution?
I don't want to make that statement yet. It seriously impairs that possibility. But until we have fully evaluated the facts which we have developed and considered what appropriate steps should be taken in view of the pardons, I can't make that statement yet.
You've worked for years on this. Was it a wasted effort?
No, it wasn't a wasted effort, because what it has done, first of all, there were 14 indictments, 11 of which resulted in convictions, 2 of which were awaiting trial, and 1 of which was dismissed because the administration, the Bush administration, would not release publicly known but classified information. So there were each of these cases was tried to a district judge and to a jury. The charges were found legally sufficient, and the juries found every person who went to trial was found guilty of a felony or multiple felonies. And there has never been any question as to the sufficiency of the evidence to support these convictions. The reversals which occurred in the North and Poindexter case were because Congress granted immunity to them, and the court felt that even though we'd taken extensive efforts to insulate ourselves from the immunized information, that nevertheless the exposure of third-party witnesses required a reversal. So I think that the demonstration that persons committing these acts can be brought to justice and can be convicted before jurors, and the careful and intelligent display of concern that each jury has manifested in reaching these decisions. There were no snap decisions by jurors. They were carefully thought out decisions. I think is a very encouraging sign for the administration of justice. And to me it means that the careful work and the lengthy work that we have done to bring these cases to trial were truly worthwhile. Further, it was the constant exposure and the threat of exposure in the Weinberger case itself that brought on this sudden concern for a pardon. You might ask, if a person is going to be pardoned, why wait 6 years? Or if a person is indicted in June or July, why wait until after the election before pardoning him? These are questions which would occur, I think, to most people. And so I think the exposure of the entire process, including these pardons, is a worthwhile development for the public's understanding of its government, of how government should be conducted and how it was conducted under the Reagan and Bush administrations.
Weinberger said, after the pardon was announced, he said that you have made a mockery of law enforcement and justice.
That's what Weinberger said. Well, he's a biased person, a biased observer, one might say. And the fact is that when he was confronted that as this trial approached, the intensified efforts to pave the road to pardon by Mr. Weinberger's counsel and by public figures who were friendly to him has shown that he did not regard this as in the least bit frivolous or as in the least bit unlikely to lead to a conviction.
Mr. Walsh, the president goes on to say about independent counsel that you represent a troubling development in the political and legal climate of our country, basically the criminalization of policy differences.
I'm sure it's troubling to President Bush, and I'm sure it was troubling to President Reagan. But the thing is that unless you're going to accept the premise that a public officer can lie to Congress when Congress is proceeding by its committees, these are not stray corridor conversations. These are inquiries posed by a congressional committee challenging the policy of the president. And the president is concealing conduct which he knows is in violation of congressional policy. To say that that's simply a political difference, a lie to Congress is not a matter of political opinion. That is a crime. A person going before a congressional committee has three options. He can tell the truth, he can refuse to answer, claim executive privilege, and then that brings down the wrath of Congress, of course. Or he can lie. Now, the third option is criminal. That is not political.
Mr. Walsh, were you surprised by the timing of today's pardon?
Yeah, I am. I was, because it waited right up until the eve of the trial. The trial is scheduled for January 5th. I would think that if there was going to be a pardon, that the pardon would have come earlier, particularly when we are all concerned with the time that my investigation has taken and with its expense. Why prolong it if they're going to pardon? So it's a funny development in that sense. The timing, I think, is unusual. To wait while everyone else went through their trial and were found guilty, and then to pardon this person as he's about to start his trial.
You make it sound like you were almost expecting a pardon, but much earlier.
No, a pardon is always a possibility, but I really didn't think the pardon power would be used in a case where it could be so easily recognized as a cover-up.
What's your perception of Bush's motivation for this pardon?
I don't want to speculate on that.
Mr. Weinberger today said that he thought you tried to force him to give untruthful testimony.
He said that more than once, and that is a false statement. There was never any such proposal. He was invited to tell the truth as to what he knew. No one has ever suggested that he give false testimony or that he testify against any particular person. That would be, not only would it be improper, it would have been foolhardy for a prosecutor to do that. That's the last thing he wants, is somebody giving false testimony in an investigation like this, where you've taken so long to develop truthful testimony.
Is this over now, or where do you go?
Well, we're going to have to evaluate our situation. In the light of this, it certainly has reduced the likelihood of further prosecutions, but I say we want to examine every possibility before we reach that final conclusion.
And you don't think
who's left that could be prosecuted?
Well, I don't think it's proper for me to name those names. I'll leave that to you to.
So what's next for you? You're out of a job?
No, I have a law firm that's been keeping my office for me for a long time, so I'll come back and go to work for them. But we first are not finished, and I don't want to make any decisions or any moves until we have carefully gone over the options available to us and then gotten our report out. Reporting on this activity is a far more comprehensive and difficult job than you might think. And in the end, I hope our report is reduced to an appropriate size, but to get there, it means writing up a whole lot of prior activities that have to be at least considered for inclusion in the report.
What might Congress do with that report?
They will reach varying conclusions. And I think we have to wait and see what the report looks like before we get to that point. One of the things that we're going to have to consider, or one of the things that Congress is going to have to consider next year, is what to do about the renewal of the Independent Counsel Act. And our experience, good and bad, is going to be something that they will want to consider in what is likely to be a reenactment of that act with additional, perhaps procedural restraints on it.
In light of the pardon today, again, you don't think that the last few years have been a waste of time?
No, not in the least.
Should the public be outraged?
The public, the American public, is a very discerning and perceptive group. It will reach its own conclusion as to outrage. I think that political figures again and again misevaluate and underevaluate its strength, the strength of our public. And the public will reach its conclusion. They can see through things just as fast much faster than most people
When will your
think.
final report be ready?
I hope, I can't say now. We're going to have to regroup. We had been thinking in May whether we can do it earlier. I will have to see.
Is the message here, if you work for the government, you're above the law?
That depends on the president you work for.
You say that Congress will have to consider renewal of the Independent Counsel Act. Should there be an evaluation of executive pardoning?
I don't think so. That's a constitutional power. It would take a constitutional amendment to change it, and I don't think it should be changed. I think the power of the pardon, it's a very ancient power. It goes back before the founding of this country. It was in early English times, laws were harsh, and a trivial crime could expose you to very severe penalties, including death. And it was the pardon power of the king that ameliorated those harsh laws and that people looked to, particularly when judicial proceedings weren't very good, when there were trial by ordeal or trial by battle and the outcome was pretty bad. The pardons were necessary. So I think the pardon power should be continued, and I don't think it should be restricted. It's a matter for the conscience of the president and the judgment of the president, as reviewed by the public after that judgment is exercised. Excuse me. Sorry, go ahead.
Is there ways in which the Office of Independent Counsel should be changed?
Well, one of the biggest problems with the office is that it literally takes a person like me out of private practice and brings them to Washington without anything, without a yellow pad, without a pencil, and says, investigate 3 major departments: the State Department, the CIA, and the Defense Department, the White House, and the National Security Council. And you don't even have a place. The chief judge is kind enough to give you an empty set of judicial chambers and to go set up in. Now, it would be very valuable to future independent counsel if there could be some kind of a cadre of administrative experts and just an administrative group that he could look to help him get started and to carry him forward. The second thing would be some kind of facility. We did not choose the place that we established our office, and that was picked for us by the General Services Administration. And it had to get the approval of all of the intelligence agencies who let us have their records. So they insisted on this very high-rent place that we've had to use. If there were a decent, secure facility anywhere, in any loft building, that would be fine. But the thing is that if 40% of our expenses have been for administrative matters, using a rough figure, now that could be saved by just a place to hang your hat in a government building and a group of people who would be able to get your office going and keep track of your records and your expenses and do all the things that a law office has to do. So I think that may be something that the Congress will look at for the next Independent Counsel Act.
Sir, you indicated that President Bush was not forthcoming during your investigation with some of the groups that you would have liked to have seen. Is there a possibility that you'll go after him in some way, shape, or form?
I don't want to speculate on that until we're through. Well, I thank you very much, and I appreciate your coming down here on Christmas Eve. I didn't plan the timing of this event.